Is a law that allows a vote to be cast and counted even when the parties disagree on the validity of the ballot unconstitutional? To find out, you have to read Amedure versus State of New York, but it's 12 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Matter of Amedure versus State of New York. The citation for this case is 2024 New York Slip Opinion 05425, published by the New York Court of Appeals on October 31st of 2024. The issue in this case is whether New York's election law, section 9-2092G, is unconstitutional in that it does not require bipartisan agreement before allowing a vote to be cast and counted. To understand and appreciate the context of this case, what's helpful to know is that New York State's Constitution has a portion of it called Section 2, Article 8, or Article 2, Section 8, that's titled Bipartisan Registration and Election Boards. It states that part of the New York State Constitution says all laws creating, regulating, or affecting boards or officers charged with the duty of qualifying voters or of distributing ballots to voters or receiving, recording, or counting votes at elections shall secure equal representation of the two political parties. So if a law involves officers to count ballots in an election, it has to have equal representation of the two political parties. All right, what are the facts in this case? The facts are that during 2020, the world was dealing with a pandemic of COVID-19. And as a result, even though there was a presidential election that year, people basically still voted, but there was a lot more voting by absentee ballot than there used to be because in the past elections, there weren't a pandemic in the middle of an election. So as a result, there was a lot of delays in the recording and counting of ballots. And so in 2021, the New York legislature tried to address the problems with the existing statutory scheme of election and voting by passing new laws. Amongst the new laws that were passed was Election Law 9-209. Okay, 9-209 created a sort of new system for analyzing absentee ballots, and it creates a couple of different systems. First, ballots have to be, before returning one of a covered a ballot, an absentee ballot, a voter has to place their completed ballot inside of a ballot affirmation envelope, sign the ballot envelope, place it in a return envelope, mail that envelope or return it in person, okay? When they receive that envelope, it's first reviewed for defects that are not curable. So the first step is it's reviewed for defects that are not curable, such as the name of the ballot envelope does not match registration records, there's no name on the ballot envelope is not timely received, or the postmark is not timely, or it's completely unsealed. If it's defective in those ways that are not curable, it's presumptively invalid. But if it passes that first check, now it goes to a second check under 9-209 2G, where there's defects that are curable. And if it's one of these defects that are curable, including that the signature itself is alleged to not match the signature on file, now it's reviewed by those two board members. And the board members are two different parties, like we talked about. And if one of them, here's the way that 9-209-2G works, is if the members of the bipartisan local board charged with viewing the ballots are split, okay? If one says the signature matches and the other one says the signature does not match, in a split case, the ballot is cast and counted. If both of them agree the signature doesn't match, it's not counted. If both of them agree the signature does match, it is counted. But if one says it doesn't match and one says it does match, that split amongst the two board members results in, according to the statute, the vote being cast and counted. Okay, a split means it's cast and counted. So basically the plaintiffs then sued and said this law is unconstitutional. Why? They say it violates New York's state constitution, Article 2, Section 8. Because according to the plaintiffs, that law, because that constitutional provision requires equal representation, which they interpret to mean bipartisan agreement. It shouldn't be cast and counted unless they both agree, according to the plaintiff. It goes to the appellate division. The appellate division denies the application to find it unconstitutional, says the law is constitutional, and it's appealed to the Court of Appeals. And here, it's sort of a quick answer. They say it's constitutional. They disagree with the plaintiff. They say the plaintiff's argument fails under the plain text of Article 2, Section 8. The provision requires equal representation, meaning the same number of people on this party and this party. It does not require that the board be in agreement for something to happen. The statute says if they don't agree, then the vote is cast and counted. So no single board member has any more authority than any other. Either side, the Republican can say it's valid and the Democrat can say it's not valid, or the Democrat can say it's valid and the Republican say it doesn't matter who's making the split. The fact that either party can make whatever decision they want does not mean it's unconstitutional. And then because of that, the plaintiffs failed to meet the heavy burden of proving that election law 9-209 is unconstitutional. It's a heavy burden to find a legislatively passed law unconstitutional, and the plaintiffs fail in this case. And that's the case of Amedure versus State of New York. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.